We begin tonight with breaking news. A federal judge issues a stinging rebuke to the Trump administration's stonewalling of Congress that could have ripple effects for other potential impeachment witnesses. Tonight, Judge Ketanji Brown Jackson ruled that former White House counsel, this man, Don McGahn, must testify in compliance with a congressional subpoena. In her ruling, Judge Jackson rejected the Justice Department's claim of unreviewable absolute testimonial immunity, calling it, quote, baseless. Executive branch officials are not absolutely immune from compulsory congressional process, even if the president expressly directs such officials' noncompliance. This conclusion is inescapable precisely because compulsory appearance by dint of a subpoena is a legal construct, not a political one, and per the Constitution, no one is above the law, end quote. Judge Jackson made clear McGahn could invoke executive privilege during his testimony when appropriate. But she declared that presidents cannot unilaterally block officials from testifying, adding, quote, stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. The chairman of the House Judiciary Committee, Jerry Nadler, praised the judge's decision, saying in a statement, quote, Don McGahn is a central witness to allegations that President Trump obstructed special counsel Mueller's investigation and the administration's claim that officials can claim absolute immunity from congressional subpoenas has no basis in law, as the court recognized today. Now that the court has ruled, I expect him to follow his legal obligations and promptly appear before the committee. It's not clear how promptly that might be. The Department of Justice announced its plans to quickly appeal the ruling and said it will seek a stay to block its enforcement. McGahn's lawyer says Don McGahn will comply with Judge Jackson's decision unless it is stayed pending appeal. The DOJ is handling this case, so you'll need to ask them whether they intend to seek a stay. But while this legal fight is not over, tonight's ruling has significant implications for other Trump administration officials who've been instructed not to testify about Donald Trump's scheme to pressure Ukraine to investigate his political rival in exchange for military aid. Those potential witnesses include Secretary of State Mike Pompeo, White House Chief of Staff Mick Mulvaney, and former National Security Advisor John Bolton. Jonathan Schaub, a former attorney in the Justice Department's Office of Legal Counsel, told the Washington Post that this ruling could, quote, provide cover for other witnesses, especially former employees who are inclined to testify but feel compelled by the White House's direction not to. House Intelligence Committee Chairman Adam Schiff said the Democrats are moving forward with the impeachment inquiry while leaving the door open for more witnesses to come forward. Tonight, Chairman Schiff had this message to others refusing to testify. Quote, to all those witnesses who hide behind fallacious claims of absolute immunity, this ruling shows again how meritless their position remains. The witnesses who have defied Congress at the behest of the president will have to decide whether their duty is to the country or to a president who believes that he is above the law. Leading off our discussion tonight, Mika Ouyang, former staff member for the House Intelligence Committee and an MSNBC contributor. She's currently vice president of the National Security Program at Third Way. Glenn Kirshner is a former federal prosecutor who has worked with special counsel Robert Mueller and an MSNBC legal analyst, and Ron Klain, former chief counsel to the Senate Judiciary Committee and senior aide to Vice President Joe Biden and President Obama. He's an advisor to Joe Biden's 2020 presidential campaign. Ron, I'm going to start with you as somebody who spent a lot of time in a White House. This was something that the White House had been able to hang on to for some time, that Don McGahn, who was central to so many things that Donald Trump was involved in, was able to avoid testifying to Congress. There were a lot of people looking for this judgment tonight to understand what was going to happen to Don McGahn. I imagine the White House is very uneasy this evening.
Well, I think they are. Look, it is several more steps before we get the truth out of Don McGahn. The Justice Department, as you reported, Allie, is going to appeal and seek a stay. And even if McGahn, even if that stay is denied and he's forced to come before Congress, he can still assert executive privilege. He can assert the Fifth Amendment to avoid his own self-incrimination. So it's not clear if this is going to produce really truth-telling yet. But what it does do is it sends a powerful signal that the president can't just tell people not to come. The president can't just say, hey, we're not cooperating at all. And it really puts a powerful piece of leverage behind the House committees, the Judiciary Committee, the Intelligence Committee, to kind of get the ball rolling on getting some of these high-profile witnesses who they've been absolutely barred from talking to so far.
Glenn, let me ask you about, I want to, this particular part of the judge's opinion I want to read to you. When the DOJ insists that presidents can lawfully prevent their senior-level aides from responding to compelled congressional process, and that neither the federal courts nor Congress has the power to do anything about it, DOJ promotes a conception of separation of powers principles that gets these constitutional commands exactly backwards. Accordingly, DOJ's conceptual claim to unreviewable absolute testimonial immunity on separation of powers grounds, essentially, that the Constitution's scheme countenances unassailable executive branch authority, is baseless and as such cannot be sustained. Glenn, the only sentence I understand there is baseless and as such cannot be sustained. Tell us what the rest of that means.
So I'll tell you, Judge Ketanji Brown Jackson got it exactly right, and it is a very forceful opinion. It's also a lengthy opinion, 120 pages long. One of the other sentences, Allie, that really caught my attention is when Judge Jackson said, and I quote, "Mr. McGahn's failure to appear was without legal justification." And let me take that one step further. Donald Trump's ordering Mr. McGahn not to appear was without legal justification. That is darn near being able to say it was illegal. I don't want to mince words, but so I think this is really going to give the House some additional fuel for adding obstruction of justice as an article of impeachment, because the president has never had a lawful basis to order all of these people not to appear, whether it's McGahn or Pompeo or Mulvaney or Hicks. So hopefully we will now begin to see these people testify and provide some accurate information of what was going on behind the curtain.
And of course, Mika, we're reaching out to those people, Pompeo, Mulvaney, and Bolton. Mulvaney's lawyer has said this ruling does not affect whether he'll testify. This is Robert Driscoll. He's the attorney acting for White House Chief of Staff Mick Mulvaney. He says Mick will continue to follow the instruction of the president based on the DOJ Office of Legal Counsel opinion with respect to the House subpoena. So anybody hoping that everybody who's been resisting these congressional subpoenas will suddenly cave as a result of tonight's ruling is going to have to wait a little longer.
Yeah, that's right. This opinion is midstream. Usually when you have a district court ruling, the losing party will run immediately to the appellate court and everything's going to be on pause until the appellate court rules. But to come back to your initial question about what this means in the constitutional structure, what Judge Jackson is saying here is that Congress is the branch that constitutionally is designated to do oversight of the executive branch. So for the executive branch to say, its people don't have to show up in response to a congressional attempts to conduct oversight, that actually subverts the entire structure of the Constitution. And that the Department of Justice was arguing this goes against the founding of our country, but also it goes against past precedent. And she cites the example of Harriet Miers, the Bush administration White House counsel, who was also ordered to testify, who had also made a similarly broad claim that she was absolutely immune, and that was also rejected.
Ron, what do you think the White House's strategy is going to be in the face of Adam Schiff saying they've basically conducted and finished, got the information they need for the report that is going to go over to the Judiciary Committee? Momentarily, I'm going to be speaking with Representative Zoe Lufgren, who's the second highest ranking Democrat on the committee. But at this point, this thing is the horse has left the barn. The White House is going to have to pull together a strategy that makes more sense than the one they've employed so far.
Yeah, well, White House strategy is an oxymoron in this context of this presidency and this administration. And you know, what we've seen is already the complete blowing up of their strategy. Yes, they were able to keep several of these high-profile witnesses from appearing before Congress, but they were devastated by the career people, the less famous people until last week, who came before the Congress and told the truth in such a powerful way, like Fiona Hill, for example. And so now they face the risk that these higher-level people are going to be either compelled to testify or merely get the fig leaf they need to testify. Will John Bolton use this as an excuse to come forward and testify? Will other ex-officials who maybe are less friendly to the president start to testify? So this takes what was already a five-dimensional chess game way beyond the Trump White House's capacity to manage and adds 3 or 4 additional dimensions to it.
Glenn, let me just read to you another piece of this ruling in which the judge talks about what is missing from the Constitution. She writes, what is missing from the Constitution's framework, as the framers envisioned it, is the president's purported power to kneecap House investigations of executive branch operations by demanding that his senior level aides breach their legal duty to respond to compelled congressional process. This judge is not holding back on her view of how the president and his legal team have interpreted congressional subpoenas and, as Mika was talking about, congressional oversight.
Yeah. And there are some people who are, I think, baselessly claiming that, well, you know, maybe some of these judges just don't like Trump or his policies. You know, I'll tell you, Ali, I think the judiciary doesn't like people disobeying the law or making up laws like executive privilege to really try to avoid proper oversight functions. So, and I actually think I heard you say that Mick Mulvaney is putting out a statement that he's still going to refuse to comply. He's going to listen to Trump if Trump continues to say, don't testify. I have to tell you, that couldn't be a more squarely unlawful act. And it is in contempt of what a federal court judge just said with respect to the law. So I think these people now are really putting themselves in harm's way.
What does this do, Mika, to Democratic strategy right now? Adam Schiff has put out a statement saying the investigative work continues. We're learning additional information almost every day. But while we continue with our investigative work and do not foreclose the possibility of further depositions of hearings, we will not allow the president or others to drag this out for months on end in the courts. He's basically said by next week, possibly as early as next week, they could hand this over to the Judiciary Committee.
Yeah, and I think it's very clear that what we've learned over the course of Adam Schiff's hearings is just greater detail and greater filling in of a story that the president admitted to from the very beginning. We've known from the start the president brought a pressure campaign to bear against a foreign power to force an investigation of his most feared political rival. And that is just fundamentally wrong. So I think that Adam Schiff is feeling like it's so wrong. We cannot delay. You cannot allow the president or his aides to hold the process hostage with endless appeals in courts. And so what we know is the Department of Justice will try and delay the effect of the McGahn ruling and any other ruling to prevent these witnesses from coming forward to talk to Congress.
Thanks to the three of you for getting us started. Ron Klain, Glenn Kirshner, and Mika O. Yang.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.